I often receive inquiries, the firm often receives inquiries from people who have been caught driving without insurance. What can I do in this circumstance? Well, on a technical level, the offence of driving without insurance comes under Section 143 of the Road Traffic Act, and as we all know, any person driving a mechanically propelled vehicle on a road or indeed a public place is required to have, at a minimum, third-party insurance in place. Now, in general terms, if you don't have that insurance in place, irrespective of the reason, you will be guilty of the offence because it's what we know as a strict liability offence. And all that means, in simple terms, is that it doesn't matter if it wasn't done deliberately, even if it was a mistake, you would still be guilty. So in most cases, there would be a guilty plea or there would be an acceptance of a fixed penalty notice. Now, the one exception to that, I have to be said, if you were caught driving without insurance, would be in circumstances where you were effectively driving a works vehicle, you were conducting yourself in the course of your employment, and your employer had told you that you're insured, or you had a genuine and honest belief in that circumstance that you're insured. That part is actually a statutory defence, and you could enter a not guilty plea and defend the case in entirety. Now, it has to be said, most cases don't fall within that, and the vast majority of the time, when people are stopped without insurance, it's simply a mistake. We're all capable of making mistakes from time to time. Now, if you make that mistake, if you're caught driving without insurance, most of the time you'll be offered the opportunity to accept a fixed penalty notice for 6 points and £300. Now, if it was simply your mistake, if you accept you've dropped the ball, then my advice in most of those cases would be simply to accept your fixed penalty notice, because the 6 penalty points to be imposed is the minimum that the court could impose. Now, of course, sometimes you wouldn't be able to accept that fixed penalty notice if those 6 penalty points were going to take you to 12 penalty points and beyond, because at that point the court would have to consider your disqualification from driving. But that's something I won't cover here. It's something that you'll find covered in other videos. But there are other circumstances where you may be able to ask a court not to give you those penalty points. Now, that's something that we call special reasons, and special reasons apply where effectively there has been a genuine and honest mistake and there was good reason for you having that belief. And those things all come back to a very old case called Renison v. Nola, which dates back to 1947. Now, often people will say, sorry, I had a genuine and honest belief and I thought I was insured. Now, in those cases, that won't be enough, because simply making a mistake won't be grounds for the court not to give you penalty points. It won't be grounds for the court to make a finding of special reasons. There has to be something more. It has to be a reasonable act. And in that reasonable act, it will generally be the case that you have in some way been misled or there has been an intervening factor. Now, a very common example of that would be that if within your family unit, it might be that your husband, your wife, your partner, whoever it is responsible for arranging the insurance, and that they have made a mistake. You might be a named driver on a policy, and without knowledge yourself, the policy might have been cancelled or not renewed. So effectively, it wasn't your fault at all. You didn't know you're uninsured. Now, in that type of case, it would be a good argument to have or make application to the court for a special reason. Now, how that would take place in real terms would be that you would initially enter a guilty plea before a magistrate's court. You'd say, of course, I had no insurance, I accept that. But then the court would be asked to adjourn the proceedings to what we call a special reasons hearing, which takes place almost like a mini trial. And during the course of that proceeding, you would be required to give evidence on oath. You would have to explain, first of all, that you had a genuine and honest belief that you're insured, and also why you held that belief, what had brought you to that conclusion. Now, in addition to that, you would generally also require some explanation as to how you'd reach that conclusion. So, for instance, if it was your partner, your wife, your mother, your father, whoever it may be, who had made you believe that you're insured, you would often want them to give evidence as well, or indeed have some evidence from that party explaining what had gone wrong. Now, the reality is that if the court accepts that explanation, if they accept that you had a genuine and honest belief that you're insured, and also if they accept it was reasonable for you to have that belief, then the court can exercise its discretion not to give you any penalty points at all. And indeed, quite often in those circumstances, the court will also grant what we know to be an absolute discharge. Effectively, no penalty is imposed at all. Now, some people might talk about these things and call them loopholes. The reality is it's just the law. It's a matter of fairness, because of course, most people would say, well, hold on a minute. It's not fair that I'm given penalty points for driving without insurance when I haven't done anything wrong. There was no way of me knowing that I was insured at that time. And as I say, this is something that we deal with quite regularly. So if you do find yourself in that predicament, hopefully this video has been helpful to you. And indeed, if you have any questions, you can always give us a call.